Hello, everyone, and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we'll share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to our speakers to get us started.
Thank you so much, Mona. My name is David Hall, and I'd like to welcome our audience to today's webinar. We're going to be talking about tackling PBMs, navigating employers' legal risks, and growing financial burden. As we know, healthcare costs keep rising no matter what they say in Washington, D.C. or how they try to stop it. So we're taking some unique perspectives today and also some hopefully basic but much needed education around things like fiduciary duty for plan sponsors of health and welfare plans. So without further ado, I'm going to jump in and introduce our speakers. We could go to the next slide. Our speakers today are Tim Kennedy and Ann Tyler Hall. Tim is a partner at HBL. He is located just outside of Philadelphia, Pennsylvania, in Wayne, Pennsylvania, and he spearheads many of the contract negotiations that our team performs on behalf of plan sponsor clients who are proactively seeking to fulfill their fiduciary duty in an effort to avoid fiduciary breach litigation and, quite frankly, pay a lot less than their peers who aren't proactive in thinking about these issues as perhaps they should be. Ann Tyler Hall is our managing partner, the founding partner here at Hall Benefits Law. She has driven the growth of HBL from a law firm that started in 2013. She left large law firms. She was at Austin and Bird and then King and Spalding. Started HBL in 2013, and now we serve clients in 40 states. And she is also the driver of these negotiations in terms of both concept and performance. So when we negotiate these contracts, Ann Tyler Hall is frequently in the background, making sure that we leave no stone unturned and that our plan sponsor clients get the very best contract terms possible. And we'll talk about why that's so important in terms of fiduciary duty. Let's go ahead and advance the slide. I'm going to just give a very brief overview of what today's presentation will look like so you know what to expect. This is a very broad topic, and as such, we've broken it down into some hopefully bite-sized, understandable chunks for you. So there will be 7 sections in today's webinar. We're going to cover fiduciary responsibility of plan sponsors under ERISA for health and welfare plans, as you see here on this slide. We'll talk a little bit about how TPA and PBM practices can act as a trigger for fiduciary breach and fiduciary breach lawsuits. We'll dig in a bit looking for red flags inside of TPA and PBM, specifically those PBM agreements that plan sponsors have between themselves and the PBM, pharmacy benefit manager. Legal standards to ensure reasonable costs, some of the things that we looked at as a legal team from our perspective as a law firm from an objective, unconflicted perspective. What are some legal standards that can ensure reasonable costs for you, the plan sponsor? We'll talk about conducting due diligence to select and monitor pharmacy benefit managers, which is an important part of the fiduciary responsibilities of a plan sponsor. We'll talk a little bit about the power of an independent audit and independent audits of claims and things of that nature, and why it's so important to be thinking about that even after you've negotiated your contract. And then we'll talk a bit about legal remedies and fiduciary liability for mismanaged contracts, which again are rampant in today's landscape. And so with that, I'm going to turn things over to Ann Tyler Hall. She's going to talk a bit about fiduciary duty in health and welfare plans. Ann Tyler?
Great. Thank you, David. Excited to talk to the audience today about an important component of developing protection against a fiduciary breach lawsuit for the group health plan, for employer-sponsored group health plans. And this is really the TPA, the group health plan, third-party administrator, and pharmacy benefits manager negotiations not only buttress fiduciary compliance, fiduciary protection, but we've also leveraged these negotiations for significant fee concessions. To date, since we started negotiating these agreements, we're at $30 million in fee concessions for our plan sponsor clients. We've negotiated with all of the BUCA, Blues, United, Cigna, Aetna, Ameriben, Meritain on the TPA side. On the PBM side, all the big three, Optum, Express Scripts, CVS Health. And so not only is this endeavor, this negotiation, protective from a fiduciary compliance standpoint for group health plans, it also yields hard dollar savings. And so that's an exciting component of our firm and where we're leveraging changes in the law to benefit our plan sponsor clients. Before we dive too deeply into the nuances and contours of these negotiations, wanted to set up and frame how this came about, how we started negotiating with rigor and across a broad array of clients and plan sponsors. Over the last 5 to 6 years, we've seen significant changes in the law impacting group health plans. Specifically, the Consolidated Appropriations Act 2021, signed into law by President Trump at the end of the first Trump administration. It was a bipartisan bill. Interestingly, benefits is a bipartisan issue, so we've seen a lot of changes in the past 5 years, and I think it also is indicative that we are likely to, with the second Trump administration, to continue to see changes in benefits and in benefits law. And we'll talk a little bit more about that in some of the Trump executive orders impacting pharmacy benefits managers. But CAA 2021, signed into law at the end of 2020, ushered in some of the most sweeping changes to group health plans since the Affordable Care Act. So at HBL, we started thinking about how do we make sure that our plan sponsor clients are protected in their third-party administrator pharmacy benefits manager agreements, because so much of those changes implicated the TPA or PBM relationship, and particularly some of the transparency requirements required that the TPA, PBM, other service providers, brokers cooperate with the plan sponsor. So originally we went into these negotiations, these discussions with the service providers, with the TPAs and the PBMs, to buttress fiduciary protection, to make stronger and more market terms that were at least neutral or more more plan sponsor favorable, because as they existed when we came into the negotiation, the terms were very service provider friendly. So we started with the buttressing terms and strengthening fiduciary compliance protection and just compliance with some of these new CAA 2021 requirements, such as the MAPIA comparative analysis disclosure. We had to have the TPAs cooperating with us and providing that information. And so some of the changes that we developed and implemented into the group health plan, TPA and PBM agreements were born out of working on the compliance issues related to the CAA 2021 and getting real resistance from service providers. But this is absolutely information that we had to have, that the plan sponsor had to have to comply with these new changes in the law. But when we looked at the fees in specifically the third-party administrator agreements, we noted that due to the changes in the law, the fees needed to change. And so we started negotiating the shared savings fees, base admin fees, and benchmarking those fees as well. And that's been one advantage of doing a lot of these agreements, is that we at HBL have been able to develop an internal benchmark, which provides invaluable data as we move forward through the TPA and PBM negotiations, because we've negotiated, again, with the BUCA, the big three PBMs. We have been able to develop market rates for some of these very costly, expensive line items in the TPA and PBM agreements. So what we have also seen with those changes in the law, the CAA 2021, not surprisingly, plaintiffs' attorneys started to develop theories to sue group health plans. And interestingly, the CAA 2021 ushered in changes that mirrored what we'd seen on the retirement plan side a decade earlier. And so, not surprisingly, retirement plans have been sued at an alarming and surging rate over the past decade. And so now we see plaintiffs' attorneys taking those same concepts and applying them in the group health plan fiduciary breach context. We've seen Wells Fargo, JP Morgan, several other larger clients and smaller plan sponsors getting sued. And not only does the group health plan get pulled in to the lawsuit, but they are actually naming individual committee members. We also saw, I mentioned this briefly earlier, that with the CAA 2021, we also saw new transparency requirements issued over the past 5 years. And that, again, has driven the participant or plaintiffs' lawsuits, because plaintiffs' attorneys have been able to leverage, yes, you now have transparency, you know the fees that, or you should know the fees that you are paying the service providers, and they're significantly above market, or they haven't been negotiated and they aren't reasonable. I would emphasize this last point on the slide. I think we have entered into, well, we know we have entered into a new era for plan sponsors where it's not advisable to sign a contract with a service provider for the group health plan, set it and leave it. And passivity is very risky. And so it takes active and ongoing continuous monitoring of the fees and negotiation of the service provider fees. The DOL emphasizes fee reasonableness, and part of the genesis of the transparency rules that were rolled out for group health plans were really getting at Congress and the agencies trying to understand why healthcare costs were increasing so exponentially, so quickly, so rapidly, and then giving plan sponsors the information that they need to evaluate and benchmark the service provider fees. And so it's extremely important for plan sponsors to not only obtain those fees, but to engage in benchmarking and RFP for the various service providers to determine whether the fees that they're paying are reasonable. Now, there's not an exact explicit safe harbor definition of reasonable, but it's generally market. And in order to understand market, you have to have a juxtaposition or a comparison with other service providers. And that's, again, why it's been so beneficial the more and more TPA and PBM negotiations that we've done at HBL, the development and continued ongoing development of our fee benchmark for the service provider negotiations. Monitoring includes performance and compensation tracking. Again, this is an ongoing obligation. I've said this previously, but inaction or over-reliance on the vendors and their assurances that these are market rates, that the group health plan or the plan sponsor isn't overpaying, or the participants aren't overpaying for the services to the plan, is not prudent in this environment with all these new changes in the law and the transparency requirements. Now I'm going to turn it over to Tim to talk about how TPA and PBM practices can trigger fiduciary breaches.
Yeah, thanks, Ann Tyler, and thank you, David. I'm also excited to talk about this issue. As Ann Tyler mentioned, we've negotiated now dozens and dozens of these agreements with great success. So it's always fun to talk about something that's working. And this topic here is talking about how the TPAs and the PBMs, how their practices can trigger fiduciary breaches. And the first practice they engage in is in almost every case, the PBM and the TPA draft their own agreements for the group health plan, their group health plan clients to sign. And the group health plans will often just sign it without really reviewing it and negotiating it. The problem with that practice is the agreements are designed in a way to hide certain fees. And we'll talk about this in a second. We're talking about rebates and we're talking about spread pricing. And as Ann Tyler just mentioned, you know, plan sponsors are fiduciaries to their group health plan, and they need to have all of the fee data in order to make a determination as to reasonableness. And the agreements right from the get-go are an issue, a fiduciary issue. So it's really important that group health plans get ERISA counsel involved either before, preferably before, or after the process, so we can look and get as much of the fee data as we can. Getting to this slide here, the PBMs and the TPA fees are a little bit more transparent, but the PBM fees are they get fees in numerous different ways, but the two most important, the highest generating methods for them to garner fees are spread pricing and the rebates there. And spread pricing, just to give you an example using dollar amounts, if you have a drug, for example, that's $10,000, the PBM will charge the plan the $10,000, but the PBM will have a separate agreement on its own with the uh, pharmacy, whereby they reimburse the pharmacy for, let's say, $7,500, and the PBM will keep that $2,500. That's the spread amount. Which, we can argue back and forth whether that's an appropriate method of garnering fees, but uh, the problem becomes they do not disclose either the dollar amounts that they take or the percentage of the spread. Sometimes they don't even tell you that they're taking it, and you have to sort of dig around and discern that. But even if you determine they're charging spread pricing, PBMs are very reluctant in sharing any information connected with the spread pricing. Um, the second are the rebates. The rebates are essentially what the drug manufacturers pay to the PBMs. It's a fee that they pay to the PBMs in return for the PBM listing their drugs on the plan's formulary, the list of drugs that the plan will cover. And the PBMs the drug companies will pay that amount to the PBM so that the PBM lists that higher and more prominently on the formulary in return for these rebate amounts. Oftentimes, the PBMs will promise to pay 100% of those rebates to the group health plan client. Um, the issue we found, Ann Tyler and I, in having dug through many of these, is that they will get a fee from the drug manufacturer, the PBMs will, and they will characterize a portion of those fees as not rebates, so that the remaining portion is the rebate and they'll pass it on to the client. And if they say in their agreement with the client that they're going to share 100% of those rebates, their position is, well, we got $100,000 in fees from the drug company. We, at our discretion, characterize only 70,000 of that as rebates, and we shared 100% of that 70,000, and then they pass it on. It's obviously a game, but most importantly, it's important that we get that fee data to better understand the rebates. And then that last box there is the data access. This is obviously an issue. Almost every state in the country is either has enacted laws or is in the process of enacting laws to gain more access to PBM data, among other things. And there's also a federal law called the Drug bill that's trying to work its way through Congress to be enacted, but its goal is the same thing, among other things, is to get fee transparency. And then recently, and we'll talk about this in a second, the Trump administration has issued a couple executive orders, one of which gets right to the heart of this fee transparency issue. And Tyler, if you could go to the next one. And this slide deals with litigation. We have seen, as Ann Tyler mentioned, you had this cottage industry the last 20 years or so where plaintiffs' attorneys were suing 401k plans, excuse me, and 403b plans for fiduciary breaches. And it was a lucrative business for these plaintiffs' attorneys. And the low-hanging fruit has been picked off on the 401k side, and fiduciaries have smartened up and streamlined their processes so they're better protected. That is not necessarily the case that we're finding on the group health plan side. These plaintiffs' attorneys are now looking to sue, and they are in fact suing plan sponsors of group health plans. And the first two cases there, Stern and Lewandowski, essentially allege the same thing, that the plan sponsors failed to negotiate the document. They failed to, as a result of that, they failed to understand and document their understanding of the fees that they're paying. They failed to monitor the fees, and they failed to consider alternative vendors to provide these things. So the plan sponsors, this is the perfect, for plaintiffs' attorneys, these types of plan sponsors are the perfect target for them, because if these plan sponsors haven't protected themselves, haven't negotiated the document, haven't understood the fees, they are at great risk of losing those lawsuits. So that's where we come in to help our clients and do this negotiation process proactively, because doing nothing is not an option in this case. In fact, that's exactly what the plaintiff's attorneys want to see. That third bullet, there is a pattern here. The pattern is essentially proactive actions by the plan sponsors with ERISA counsel will provide enormous protection. Failure to do this will result in litigation, which is, even if you're in the right and you end up winning it, the lawsuit is expensive and it's embarrassing. So it's something that can be avoided through proper proactive steps. I think we talked about that last box. And Tyler.
Well, and before Ann Tyler jumps into our next section, I just want to add that Tim said something that's very true. It's obviously a game, right? The TPAs can game the system. The PBMs can game the system through their contracts. And if plan sponsors don't review those contracts, then there's really nothing you can do other than wait to be sued or pay too much as you go, or both. Right. And so the irony here is that the plaintiff's bar is using the very same principles that plan sponsors can use to beat the TPAs and the PBMs at their own game. And all the tools are right here at your disposal. But the irony is that so many people are standing pat and just playing a waiting game. And so we'll look at some red flags and common pitfalls now. But the point I'm trying to make is that you can look at this as a game, and if you're not taking action and you're not getting in the game, then you will end up on the losing end. And Tyler?
Thanks, David. So specific red flags and common pitfalls in TPA and PBM agreements is the next. We'll dive into that. And Tim's already talked about spread pricing and rebates. Those certainly are two areas where there are fees that are hidden, and still a lack of transparency, notwithstanding the CAA 2021 and all the new transparency requirements as part of CAA 2021 or separately as new regulations and guidance have been implemented. notwithstanding these new requirements, these new rules, it's still difficult to get the fee data. And so part of the value of this, of the TPA and PBM, the group health plan, third-party administrator and pharmacy benefits manager negotiation, is getting the fees. And it often takes HBL as ERISA attorneys asking multiple times of the service provider. We develop very specific fee, both direct and indirect compensation requests that our plan sponsor clients have never seen before. And so part of, again, the value is understanding the total direct and indirect fees that are paid. And this is important too, because we're seeing on the retirement plan side, plaintiffs' attorneys are suing retirement plans and retirement plan fiduciaries for prohibited transactions because the fees that they were paying were not reasonable. And again, that's a bit of an open-ended term, but you have to know what in fact you are paying the service provider, both in direct and indirect fees, in order to determine whether what you're paying them is reasonable. So part of, again, the value of this negotiation, these negotiations, is we get all of that data. There have been circumstances where we ask and ask for the data, the service provider refuses to provide it. And so we extrapolate from the information that we have, the fee data that we have, and we assume the worst. And sometimes that motivates the service provider to provide us more information. Sometimes it doesn't, but we're able to leverage that in our negotiations. But the plan sponsor has to have that information to ascertain whether the fees are reasonable and be able to compare those fees with other market service providers. And we have yet to come into a contract negotiation, TPA PBM negotiation, where the plan sponsor has that information or has, quite frankly, ever seen some of the indirect and even direct compensation that's paid to the service provider such that they understand in totality what the total fees are.
Yeah, Tyler, if I could jump in real fast. Even in the cases where we request the fees and they refuse to share them, from a prohibited transaction standpoint, it's important as fiduciaries. There's value in having requested it 2 or 3 times. That we can show the IRS or the DOL, anybody who's challenging that as fiduciaries, you did your best to get that fee data. So even not getting it there's value in asking for it.
Great point. And we're seeing now with the second Trump administration in April, Trump issued an executive order requiring the agencies, specifically the Department of Labor, to issue clarifying guidance that PBMs are in fact subject to the intent was that pharmacy benefits managers would also be subject to the 408(b)(2) disclosure requirements. And we've seen that push back a lot in these negotiations. Well, we're a pharmacy benefits manager, and it's not entirely clear that the 408(b)(2) rules apply to PBMs. Our position has always been, yes, they absolutely do. But this will be extremely helpful going forward. We're expected to get, or Trump has asked that the agencies issue these final regulations on clarity with respect to the 408(b), ERISA 408(b)(2) transparency, both direct and indirect fee disclosures, no later than May of next year, May 2026. So again, we're seeing this administration, it's still a bipartisan issue around group health plan costs and fees and transparency. And I think we're going to continue to see very good legislative regulatory tailwinds with respect to these types of negotiations with group health plan service providers. Some of the contract provisions, problematic clauses in contracts, gag clauses, prohibited by the CAA 2021. Gag clauses essentially block access to transparency, fee transparency, and lower cost health plan options, and those are prohibited. And so one of the things that we do in these negotiations is to make sure that we are requiring the service providers to prohibit gag clauses in both the group health plan, our client's agreement with that service provider, but also in any ancillary service providers to the TPA and PBM. Tim talked about spread pricing. Still very difficult to get transparency around spread pricing. We think we know why, because a lot of money is flowing to the PBMs through spread pricing. And so this is one area where if we don't get transparency with respect to this line item, we assume the worst, and then we negotiate fee concessions from that standpoint. Rebate opacity, Tim talked about that as well. And what is defined as a rebate is always drafted in favor of the PBM. A lot of contracts exclude the most expensive drugs from the definition of rebate, where rebates would be very rich to the plan sponsor. Those are excluded in the definition of rebate. So the definitions in terms of the PBM contracts and the TPA contracts, very important to review, to understand, and to negotiate. I mentioned this as specialty drug carve-outs from rebate definitions, very popular among the big three PBMs. And this is where most of the money is, where most of the rebates and money that would be flowing back to the plan sponsor is. And those specialty drugs with significant rebates are then carved out of the definition. We also see the definitions of brand drug and generic drug very fluid and very PBM or service provider friendly with respect to those definitions. And they give the PBMs often way too much latitude to manipulate the definition to increase their fees. Some of the hidden traps and liability risks that we've seen in the contracts that we've negotiated: indemnification provisions. We often see a very almost impossible to prove standard in the contracts that we've reviewed. And so one of the softer negotiation provisions or buttressing the fiduciary protection is lowering that indemnification provision or I guess increasing the indemnification standard, making it more difficult for the service provider to be indemnified for mistakes or losses to the plan. But we often come into contracts that are very favorable with respect to indemnification to the vendor, to the service provider, the TPA or PBM. We've also seen audit restrictions, very narrow audit terms and audit rights of the group health plan and the employer plan sponsor. And so we've been very diligent about broadening those audit terms and provisions to favor the plan sponsor so that they have latitude to hire an independent auditor to do a real sampling, not just a tiny sample size that really doesn't help them understand if the terms of the contracts are being adhered to and the negotiated fees are being actually implemented when it comes to payment of claims. So broadening the audit terms of the contract are incredibly important. Take or pay clauses and carve-outs obscure real costs. Those are just some of the provisions that we see in contracts. And again, it can't be emphasized enough that we, prior to the passage of the CAA 2021, a lot of our plan sponsor clients had a set it and leave it approach to group health plan, third-party administrator, and pharmacy benefits contracts. And that era has really ended as an advisable posture for group health plans and employer plan sponsors. There's just simply too much risk, but there's also incredible upside to the negotiation of these contracts. And as I mentioned earlier, to date, we've negotiated fee concessions totaling $30 million, with another $10 million a year coming back to our plan sponsor clients annually. So leveraging those changes in the law to benefit our plan sponsor clients. We often see in contracts a disclaimer of fiduciary status. We have negotiated those provisions to make it clear that no matter what a contract term provides, if the service provider is functioning as a fiduciary and has discretion, any discretion over plan administration or plan assets, then they will be deemed a fiduciary. And so there's no exculpation of fiduciary status when it comes to the way the Department of Labor and the agencies look at a 321, an ERISA 321 fiduciary, which is anyone who has discretion over plan assets or administration, but holding the service provider accountable for fiduciary type functions is incredibly important. And again, buttresses that fiduciary compliance protection that is so important to mitigate against the risk of a participant lawsuit. Tim, I'll turn it to you.
Yeah, thanks, Antara. On that last point with the disclaimer of fiduciary status, all PBMs try to disclaim that. And Antar's right that we do put in that functional fiduciary language, which sometimes the PBMs will say, well, that's true, regardless of whether we put it in there, which is absolutely accurate. If the PBM exercises discretion, they're going to be considered a fiduciary under ERISA. But we like to get that language in just to make it crystal clear. And we've also had success in agreeing to the PBM. We say, okay, you're not a fiduciary. We get that. Our main concern here is that you're not going to engage in any fee generation that's in conflict with the interest of the plan and the plan participants. And in a few instances, we've had success in getting that, I think, reasonable request added to the agreements. It's an important part of the process for sure. This next part is the defining reasonable under ERISA. And that first box, Ann Tyler, if you can go to the next slide, is an important one. You know, there is no price or dollar amount, depending on the size of a plan, that is the threshold amount where you've breached fiduciary obligations or not. Under ERISA, the focus is always on the fiduciary process. So you know, it's well settled under ERISA that you know, a benefits committee can, for example, on a 401k side, they can make a decision to invest in investment A, and investment A a year later may not be the right investment. And investment B should have been the investment. But as long as those fiduciaries have done their due diligence and have documented a rational reason for selecting investment A, the fact that investment A turns out to be the wrong choice a year later should not cause fiduciaries to have breached their process. The only way they're saved from that, though, is by having a process and following it. And that gets us to the second dot box there, which is not only do you have to have the process, you need to document it so that if you're ever challenged on it as a benefits committee and as fiduciaries, you can show all of the homework and due diligence that went into every fiduciary decision that was made. Sort of a side benefit of that process is you end up accumulating benchmarking data, which can help you in future negotiations. And we certainly do this on our side. We have our own internal benchmarking, and we do market research, and it helps us know exactly where we can land or we should land on fees, both TPA and PBM fees, which is important process. That next box is a lawsuit that was brought against the University of Pennsylvania, which was a plan sponsor. And it's interesting, and it ties into this concept that we're talking about here, is that you know, the plaintiffs allege that University of Pennsylvania had not done anything with respect to fees. They hadn't negotiated the document. They'd failed to get competitive bids. And the court was agreeing to that. The court basically said, you did nothing, and that's a problem. So this was a 2019 case, by the way, on the 403B side. But the lesson from that case is that doing nothing is dangerous. They ended up settling for $13 million, University of Pennsylvania did. And that's $13 million that just didn't need to be paid had they just taken a couple proactive steps prior to that. And that's really the big message here is that, it's very helpful to you as fiduciaries of group health plans to take action before any lawsuit comes down the pipe. The final box is maybe the one I should have started off with here because we're talking about reasonableness under ERISA, and Ann Tyler's right and said a couple times that there is no clear definition. But under ERISA, so we're talking about lawsuits and litigation, but there are also excise taxes that can be imposed on group health plan sponsors as fiduciaries for prohibited transactions under ERISA. Under ERISA, you have Section 406, which basically says, starts from the position that a plan cannot do anything with its assets. And so to take any action, you need to go look for one of the exemptions. You have to fit it within an exemption. The exemptions are listed under 408 of ERISA. And the exemption that discusses reasonable fees is 408B2. And that's the one we've been talking about today. But basically, you fit that exemption by showing that you've requested and reviewed all of the fee data, and you as a fiduciary have been able to make a determination that the fees are reasonable. If you are unable to get all of the fee data, it's impossible to show that you've made the fiduciary determination as to reasonableness. That's why so much of what we do is designed at getting at that fee data and being very dogged about it. Because it's designed to get you guys the information you need to fit squarely within this exemption, which is really, really important. And as Ann Tyler mentioned, there's an executive order that's focused on this. We'll talk about that at the very end, I think. Ann Tyler, if you could go to the next slide. Like I said, we've negotiated a lot of these agreements now. We have our benchmark and we have our market research. And we know for the most part a lot of the tricks of the trade, and we can protect our clients against that. Part of one of the services we provide to our clients is ERISA fiduciary training. This is required for all fiduciaries to have periodic ERISA fiduciary training. We provide that. And during that process, one of our big recommendations is that they ought to take their vendors out to bid. So going through a periodic RFP process for each of their vendors, not just the PBMs, not that it is necessary from a fiduciary perspective. We like to tie that RFP process up with the negotiation process so that when we're negotiating, we also initiate an RFP process so that the PBMs and the TBAs are forced to realize the value of you as a client and forced to reassess and bring the fees down to a reasonable manner and show that they value you as a client. That last box, by the way, there's a mention there of pass-through PBMs. That's a new type of structure where all of the fee data is fully transparent, and that's a nice option, and it's one we also look at whenever we RFP our client group health plans, because the full transparency gets you out of that ERISA fiduciary breach issue we've been talking about, where you cannot make a determination as to reasonableness unless you get the fees. So that does get you out of that. Oftentimes the fees for a pass-through are a little bit higher, even though through analytics and mobile phone apps, the actual overall drug spend does come down. The last box is, we've been talking about rebates, and we know that PBMs won't share the rebates with us. So we've had to come up with a general rule of thumb where we take, and it works, by the way, because regardless of whether the PBM says they're going to share 100% of the rebates, we know that oftentimes that's not the case. The rule of thumb is we get the overall drug spend, we get the actual dollars that were shared with the client in rebates. And if those rebate dollars are not more than, let's say, 27, 28% of the overall drug spend, that's a very clear indication to us that not enough of the rebates are being shared with our client. And it's a signal to us to dig a little bit deeper on that issue. So that's just one example of the type of strategy we use when we look at these agreements.
And there's something like 12 or 13 different levers that HBL can look at within the PBM contracts. And very similar to the TPA contracts, when you squeeze the balloon in one area, oftentimes what happens is the air or the money in that contract goes to a different area of the balloon. So it's important to look at the contract as a whole from each of these different perspectives. So as we look at these examples, just know that there's a holistic approach to these contract negotiations. And Tyler?
Great. So we're going to pivot to conducting due diligence and selecting and monitoring TPAs and PBMs and some of the best practices in vendor selection. Tim mentioned issuing periodic RFPs, requests for proposals, to get a sense of a comparison and a benchmark within the different service providers within the BUCA. And that's extremely helpful. But we often get asked when to incept the negotiation. And we also get a lot of feedback from our group health plan sponsors. Well, I'm in the middle of a contract, and we've never seen a contract that doesn't give the service provider very broad latitude with respect to being able to get out of that contract, really with very little notice, and certainly for certain situations to get out of that contract immediately. So typically what you're seeing from a service provider, we just saw this, is a 3-year, for example, price sheet, which could also be changed if there are changes in the market or changes in the demographics or employee size. So there's really no set contract term. Now, we also understand that our plan sponsors don't want to leave a contract mid-year, but we leverage these negotiations such that it doesn't really matter if your contract has been is in the middle of, for example, in June of a year. We've incepted a negotiation. And I think we've incepted a negotiation at every month during a year. And the reason is because the reality is that the contract is very flexible with respect to the term of the agreement, and the service provider can exit really with little advance notice, and so can the plan sponsor. And so our approach is that if we, and we always do, get in and see that the fees are too high, our client has been paying excessive fees for now several years, and the time to negotiate the contract is now. So we always tell our plan sponsor clients and our prospects that the time to negotiate the contract is now. Also, it is extremely beneficial to negotiate the contract sooner rather than later, because participants, plaintiffs' attorneys, continue to troll for more group health plans to sue, and we're seeing that weekly with respect to the surge in fiduciary breach lawsuits, and specifically targeting group health plans. We've done contract negotiations pre and post merger. So clients that are in acquisitive mode or post acquisition, they're a larger entity. And so we leverage those employee headcount increases to get a better contract, better fees. It's extremely valuable to negotiate the contract just prior to an RFP. And this is important because we're able to leverage the fact that the group health plan, the plan sponsor, is going to be looking at the service provider's fees in the context of some of their competitors. And so we negotiate the contract just prior to the RFP to get a best-in-class fee concession and fee terms. And that also tees up for the ensuing years and for the RFP process, and whether the plan sponsor will maintain that relationship with the service provider or transition to a more competitive service provider. It's important that you engage ERISA counsel. The group health plans engage ERISA counsel because ERISA counsel is uniquely positioned to leverage changes in the law. At HBL, we have an internal benchmark, and so we have a sense of the market for these fees. We've negotiated with the BUCA and the big three PBMs, and so we understand where the fee concession opportunities are and the terms and provisions to be negotiated to buttress fiduciary compliance protection for the group health plan and the fiduciaries. And then there are a myriad of different state laws, state PBM laws that must be monitored and carefully reviewed in the context of these negotiations and can be leveraged in the negotiation. And so ERISA counsel is uniquely positioned to do that. We, in these negotiations, of course, prioritize transparency. You have to understand what the fees are, the total fees, the line item fees. Again, audit rights, very important, and making sure that incentives are aligned to the group health plan. Tim, can you talk about some of the conflicts of interest provisions that we've seen and how we've negotiated those conflict of interest provisions to protect the group health plan and the plan sponsor?
Sure, if you can just jump to the next slide, please. Sorry, Tyler.
Now, I was just specifically talking about, I know that we've negotiated one of these recently, Tim, where there was really a concern around a perverse incentive. And so we went in and negotiated such that the specific language was that the service provider was obligated to disclose a conflict of interest or to make sure that the incentives were aligned with the group health plan, fiduciary protection, and not paying excessive.
Tyler, that's right. Apologies.
Yeah,
that kind of ties back to our having successfully negotiated that provision that if the PBMs are going to take the position they're not a fiduciary, we get in alternative language that we hope addresses that conflict of interest for sure. Absolutely.
And so what we've seen is we negotiate the TPA PBM agreements, we get significant fee concessions, buttress the fiduciary compliance provisions, and then we're often brought in to negotiate other service provider agreements, the fiduciary liability insurance policies, and broker agreements. It is incredibly important for plan sponsors once the negotiation is complete and the new terms, new fees are agreed upon and the new agreement is executed, that those changes be monitored and confirmed with respect to what the agreed upon terms were, and that those agreed upon terms and fees are adhered to by the service provider. And that's something that we at HBL do a lot of post-negotiation. And it's important to have ERISA counsel involved in that ongoing monitoring and documentation. And just a re-emphasis on not a set and leave it mentality, and that being extremely risky in this environment, but a constant ongoing monitoring of fees and agreement terms. It's also important for plan sponsors, and we, as part of this fiduciary compliance process, this TPA and PBM negotiation, which is incredibly protective from a fiduciary compliance standpoint, it's also important for group health plans and benefits programs to have a committee charter, and fiduciaries to have a committee charter, meet regularly to discuss the terms, the contours of the plan, the agreements, and ongoing monitoring of the service providers, and to keep careful meeting minutes as part of those meetings. And we're very involved with our group health plan sponsors pre, during, and post negotiation with respect to maintenance of a robust fiduciary compliance paradigm for the group health plan, and for that matter, the retirement plan as well. Tim's going to talk about the power of independent audits to uncover risk and drive accountability.
Yeah, I'll jump right into it. If you go to the next slide, the independent audits are critical. It's a piece, every agreement will have an audit provision. And step one for us as part of the negotiation is to review and negotiate that, because it's never as favorable as we want it for our client. Just important things like, how many audits are allowed per year, who's going to pay for it, who's going to pay for the time in gathering the documents, how much time the PBM or TPA has to produce the documents. Those are all important things that we like to do at the outset. And that's one piece of it. Once we get that audit language in place, we can use that to actually we can use the language in the audit process to get a real good sense of the PBM and TPA's compliance gaps. I mean, MAPIA and the Consolidated Appropriations Act have a ton of obligations that fall on the employer. But really, we need the PBMs and the TPAs to help us because they have all the data. And if there's not language in there that says that they'll help us, there's no recourse for us to the extent they are negligent in providing that to us. So it's a really critical. I'm moving along quickly because we only have 4 minutes. It's really critical that we get that audit language correct at the outset. And then finally, our recommendation is to do one per year, especially if the PBMs are going to pay for that, which we typically try to negotiate. And then once we get the information from those audits, it's very helpful in informing and for using and leveraging in the negotiation process for the subsequent year. Because if the PBMs or the TPAs are doing a poor job, or there are service or compliance gaps, we need to know that. And they need to account for that. And we use that in the negotiation process to move forward.
I'll cover briefly then the legal remedies and fiduciary liability for mismanaged contracts. We talked about the ERISA lawsuits. There has been a real surge in fiduciary breach lawsuits. JP Morgan, Johnson & Johnson, just a few examples. A reminder that if you have any discretion, you're an employer and you have any discretion over plan assets or plan administration, you're a fiduciary, and as such can be held personally liable. And again, that's why it's so important to have a robust fiduciary compliance paradigm for your benefits programs. We've talked about the excise taxes for prohibited transactions and just the benefit of negotiating these contracts to realize money back to the group health plan and to the employer and the participants. We've had employers leverage the fee concessions to bonus employees to develop a more robust group health plan portal and online system that's easier to navigate for the participants, and just generally to lower the costs for participants of group health plan coverage. So it's exciting for us to see that the outcome of these negotiations can't be emphasized enough. Don't delay. These service provider negotiations are more important than ever. We at HBL leverage changes in the law and the really nice and important legislative tailwinds through the CAA 2021, Trump executive orders, and the state PBM laws that give us a nice impetus to have this discussion and to engage in this negotiation. The group health plan fiduciary breach lawsuits are another impetus and reason to not delay having engaging ERISA counsel to negotiate these contracts. And then we also leverage the internal benchmarks because we've done so many of these contracts with the BUCA, negotiated with the BUCA, with the big 3 PBMs. And so we leverage that to buttress fiduciary compliance and to realize significant fees back to the group health plan, back to the participants. Also important to review fiduciary liability coverage and to make sure that the coverage would protect in the event of a fiduciary breach lawsuit. This is incredibly important. We've seen, particularly for one of our clients, that tripled in size post merger, and the fiduciary liability insurance had not changed. The level of fiduciary liability insurance had not changed. So that needs to accommodate, your fiduciary liability insurance needs to accommodate and be protective for the size of the benefits program for your organization. And then transparency and vigilance, and the group health plan and fiduciaries are responsible. While Congress has required more transparency for the service providers, the group health plan sponsor has to get that data and analyze it and determine whether it's reasonable. And that's where ERISA counsel can be so beneficial to plan sponsors in helping review that data to confirm where there are opportunities for savings. And I think we're at our time.
Why don't you leave that last slide up, Ann Tyler, so folks can see some of the recent updates legislatively and from the executive branch, primarily here it appears. Everyone will receive a copy of these slides, and I would encourage you to reach out to us here at Hall Benefits Law. We've negotiated these contracts for self-insured plan sponsors with 500 employees and 25,000 employees. So there's no size self-insured plan that shouldn't be paying attention to these fiduciary responsibilities. We're so grateful you took the time to be with us today, and I hope you'll join us when we do this again in the future. Thank you so much, Ann Tyler and Tim, for your time, and Lexology for hosting this webinar.
That wraps up our
Thanks, everyone.
Thank you. That wraps up our masterclass. Thank you all for joining us today. A special thanks to our speakers, Ann Tyler, Tim, and David, for their time and efforts in preparing and delivering this session. As mentioned earlier, the session was recorded, and we'll be sharing a copy of the recording and the slides with you in the coming days. Thank you once again, and enjoy the rest of your day.
Thank you.